Thank you all for being here. So welcome to what we are also calling Law in the Age of Trump in this panel discussion today. So for many of us, I think it's safe to describe these as fairly depressing times with some longstanding norms, I think, of decency and inclusion under siege. It's especially important, I think, for our community as lawyers and budding lawyers because recent actions in the U.S., I think, call into question the very idea of the rule of law. You know, you've got a president firing attorneys, an attorney general for disagreeing with his legal views over the discriminatory nature of the Muslim ban, and is referring to judges as so-called judges, as you all know. This gives us, I think, some reason for concern. But it's also worthwhile, I think, taking a moment to focus on the positive. And I think one of those things is how we've seen the best, I think, of lawyers and the legal profession in recent days. It was through these efforts, in some cases seemingly spontaneous, in other cases more organized through things like clinics. But lawyers have been, I think, real foes of the administration in some of the recent developments. The stay that was initiated, not only as having an impact on the ground, but I think has also really been important in influencing public discourse about this, and even somebody like Trump is apparently rethinking some of his approaches to executive orders, thinking that maybe he should be getting some advice before signing them, which is progress. I'm not all that confident, but on that front, but it's interesting and important to see, I think, the role that lawyers, again, spontaneously in some cases, just going to JFK to talk to recent arrivals. I think it's a reminder of our responsibility as keepers of the flame when it comes to the rule of law. It's also, I think, a reminder of what our country can provide as seemingly one of the more vibrant liberal democracies left, and being a beacon, I think, in some increasingly foggy times. Closer to home, I'm proud of being a part of this faculty and the reaction here to intolerance, I think, with outreach and fellowship, and to bad ideas with good. So I'll stop there, and I will hand it over to the substantive experts on the matter. And as I understand it, each of the panelists will speak for about 10 minutes, and then we'll open it up for Q&A. But we have, in order, I hope, Professor Schneiderman, Brene, Eamon, Macklin, and Austin. So I will stop there and hand it over to the panelists. Thanks.
Thank you very much, Dean Iacobucci. My name is David Schneiderman. I teach constitutional law and international investment law, and teaching U.S. constitutional law this term, so it's an interesting time. So I'm going to focus in my remarks on the constitutional dimension. There's much to admire about the U.S. constitutional system, but one could say that it exhibits severe pathologies that no one would want to mimic. That it is a constitutional democracy operating on the fumes of its presumed past glory. It's a constitutional system mired in cash and corruption, operating under its own, what Lawrence Lessig calls, economy of influence, that allows the rich to do rather well. It's a system in which the executive is, as in many operative constitutional democracies, including Canada's, which the executive branch is overly powerful, controlled by a candidate in the United States who lost the popular vote by 3 million votes, keeping in mind that the turnout in the presidential election in 2016 was 55% of the voting age citizens, in which there is almost perpetual congressional deadlock. However, that might change, seeing as that Congress is now the same party as the president. But which then, because of the difficulty of getting things done, empowers the executive branch, the president, to do virtually whatever he wants in the realm of foreign policy. It's largely unchecked. realm of policy. It leads us to this situation. Bruce Ackerman, a constitutional scholar at Yale, writes this in 2010, this after the Bush debacle of entering into the Iraq War. He writes, the very same features that have made the presidency into the platform for credible tribunes of the people like Abraham Lincoln or Franklin Roosevelt are also conspiring under different conditions to make it into a vehicle for demagogic populism and lawlessness in the century ahead. 6 years before this presidential election. So what are the constitutional checks then on the Trump presidency? I'm going to focus principally on the executive order that everybody's talking about, banning the entry of persons from 7 majority Muslim countries and refugees for 90 days and Syrian refugees in perpetuity. So there are a number of arguments, and there are numerous moving parts and temporary restraining orders and injunctions proceeding in different federal courts. But principally, the arguments are turning around a free exercise clause, and that argument, and that is that the executive order burdens people of a particular religion, and so is not neutral in regard to religious freedom. This kind of claim attracts what's called rational basis review or rationality review, which is the lowest threshold of review. It's a free pass, typically. In the United States, if you label this a religious discrimination claim, in the United States, there's no constitutional cognizance of adverse impact or indirect discrimination. Only direct discrimination, intentional discrimination, is constitutionally cognizable. It's one of the only operative constitutional democracies in the world that is not interested in adverse impact, indirect effect discrimination. So courts will look at the face of the record, and of course, the Department of Justice argues there's no evident religious discrimination on the face of this executive order. Courts will sometimes dig just below the surface, right, to find if there's any evidence of intentional discrimination. So if just below the surface there's some stuff, courts will be interested in. Of course, now petitioners in the state of Washington who've had some success over on Friday argue that there's lots of evidence if you just dig below the surface. The declaration during the primaries of Trump declaring he wants a Muslim ban on Muslims. Rudy Giuliani recently declaring that he was asked to draft something like this executive order in order to achieve the Muslim ban, but legally. So you have all these kind of other statements that evince discrimination and might invite courts then to dig below the facial record. There's an establishment clause claim, and that is that the executive order favors doesn't just burden, but favors one religion over another. And again, it has to do with language about favoring minority religions in those countries that are banned, and the implication is it's favoring Christians over Muslims. That kind of religious claim attracts strict scrutiny, right, as opposed to rationality review. So I'm giving you a primer on U.S. constitutional law. Strict scrutiny, of course, is almost fatal, right, if a court applies that standard of review. But again, it has to be, as far as the court's concerned, on the face of the record or just below it. And again, both sides to the argument will be arguing about whether there is a favoring of one religion over another. There's a due process argument, denial of rights to those who hold valid visas to enter and leave the United States. That also attracts rationality review. So again, very low-level scrutiny. There isn't a lot that the Department of Justice will need to do to satisfy that. The state of Washington has raised an argument about the animus that's motivating the animosity that's animating the executive order. Animus, interestingly, attracts, according to recent Supreme Court jurisprudence, rationality with a bite. So, for instance, discrimination against gay and lesbian folks attracts rationality with a bite, a famous case of Romer versus Colorado. So when there's evidence of animus, singling out a particular class for treatment, casting them out of the constitutional order attracts a little bit deeper scrutiny. Okay, so that's what Washington has argued, and successfully, insofar as obtained a temporary restraining order from the so-called Judge Robart. The Department of Justice, not surprisingly, is arguing that the president is acting pursuant to congressional authority, which is presidential authority at the highest ebb, according to the case law. So deference, right, to the president executing his statutory authority. And also, the president, of course, is commander-in-chief and exercising authority in defense of national security. And here, the court should stand down and defer to the president's interpretation of an application of the law and threats to the homeland. It wouldn't be surprising if the Department of Justice won on that argument, right? Courts are typically deferential when it comes to national security claims, particularly in wartime and emergencies. Recently, in the series of Guantanamo Bay detainee cases, the U.S. Supreme Court was flexing its muscle, surprisingly, to some degree, conferring constitutional rights, for instance, on detainees in Guantanamo Bay. So we could see a trend line operating in favor of more carefully scrutinizing exercises of executive branch authority in national security matters, but I wouldn't be too hopeful about it. There's standing arguments that typically stand in the way of these kinds of constitutional arguments, and the state of Washington has succeeded so far, as have petitioners who are being detained. So standing is not as flexible requirement as it is in Canada, where, for instance, you could have taxpayers bring suits and having constitutional standing. In the United States, you need a particularized and concrete injury. So it seems that those, for instance, who are in the United States being detained, or in the United States and not being able to leave and return, will likely have standing. Those who are abroad won't. And yet, and also the state of Washington and Minnesota have successfully sought standing so far, and it might be that states will have standing in these cases. It's not easy to predict where the Supreme Court will come down on this, and I predict it'll go up rather quickly to the U.S. Supreme Court. At least the temporary restraining order will. The court's evenly divided on an ideological divide. Justice Kennedy, who typically is the swing vote, who's more likely to side with his Republican colleagues on the court, did decide in favor of Guantanamo Bay detainees. I got to say, though, that the President Trump tweeting will not help the Department of Justice's cause. Imagine that the argument is that the court should defer to the president, who has expertise and authority and is better positioned, right, to make these kinds of arguments. And if the president is tweeting crazy things, in particular about so-called judges, and Kennedy is very twitchy about these kinds of questions about independence and impartiality, he's not going to be happy. So he's not doing his lawyers any favors, actually, by tweeting Saturday morning. There's a couple of other things, just by way of closing, to mention. There are lots of constitutional problems going forward. Trump has refused to divorce himself from the Trump business operations, except he's saying, I'm not going to be an operating mind, but he'll continue to accrue income and revenue from Trump operations abroad. The emoluments clause all of a sudden is a front and center, which prohibits officers in the United States to receive emoluments or monetary favors from persons overseas. And it seems to me that there is an ongoing constitutional crisis or constitutional problem that might turn into a crisis There's a suit that's been launched on this basis. There's also the 25th Amendment to the U.S. Constitution, which I'm sure I saw being used in some American television show, in which the president and cabinet can divest the president of authority if they think the president is incompetent.
24.
Is it 24? Yeah.
Something.
Pretty sure it was Kiefer Thelt. Yeah. It was one of those episodes. I'm divulging too much.
So am I.
So imagine Pence and the cabinet divesting President Trump of authority because he's incompetent. Not going to happen. Now, and neither is impeachment for that matter because of offending the emoluments clause. It's really unlikely to happen as a Republican-controlled Congress. The Republican members of Congress need Trump supporters, right, to get reelected. So really unlikely. The only fun thing is to continue to talk about it and just make Trump really angry. I'll stop there.
Well, so I will zoom out a little bit. I teach international law, and I guess I can say that this has not really so far been a year where you can just teach the material. In a little over 2 weeks, the Trump administration has generated a stream of executive orders and verbal hype about ripping up the TPP, NAFTA, the Paris Climate Agreement, leaving NATO, reviewing an unspecified number of multilateral agreements, and while we're at it, the United Nations and its funding. Now, you may disagree as a matter of policy with the retreat from the TPP and the threatened withdrawal from the Paris Agreement, but I would say that if executed properly, using legal mechanisms that exist in international law, these kinds of retreats are lawful, although obviously they are likely to be highly corrosive of other states' resolve to tackle shared problems. So to be sure, a lot of damage can be done in this way, but to keep things in perspective in this respect, I think it's useful to appreciate that the Trump administration in some respects here is following in the footsteps of some previous US administrations, even if at a much grander scale and with much more sound and fury. So take, for example, the George W. Bush administration. They withdrew the United States signature from the Kyoto Protocol and from the Rome Statute to the ICC. So you might think that the Trump administration could get a fair amount of mileage out of taking these kinds of steps, that is, hype them up with their constituencies and rub them in with the allies, because you can, if you recall, back then in the days of the Bush administration, allies were actually scandalized and then to some extent also energized by what they saw as outrageous US unilateralism. But the Trump administration, I think it's fairly obvious, isn't stopping at being provocative while staying on track, legally speaking. There's something more, and I would say much more worrisome going on here. And that something more, I think, is what we all sense and what Dean Iacobucci has already referred to. And that is what accounts for these unprecedented mass displays of mass resistance. Ordinary people in the United States and around the world demonstrating, scores of lawyers coming out to take emergency action, 900 plus US State Department diplomats issuing a very strongly worded dissent memo against the Muslim ban, and foreign governments reminding the president of the need to respect international legal rules protecting refugees from war. It boils down to this, I think. When the biggest Western democracy, with a flick of the presidential pen or a lash of his tongue, runs roughshod over established refugee rights and does so in a secretive process, abruptly and arbitrarily, when there is advocacy of torture, and when the president instructs publicly and in writing to make recommendations for rules to combat ISIS that, in quote, exceed the requirements of international law regarding the use of force. Well, when all of that is happening, I think we better take notice. Because these actions aren't just policy choices over which you might legitimately disagree. They are frontal assaults on the rule of law and on legal rules that have been built over generations and often with US leadership. They threaten the very basis of the international order that we rely on to allow people of different views and different traditions to interact and reach agreement on shared purposes, however limited they may be. And if this continues, I fear that we will witness a fundamental shift in the world order, and that is a shift that is likely to result in less stability, more military conflict, and a destruction of protections for vulnerable people. Many of President Trump's supporters seem to accept the argument that the US has been a chump, agreeing to international rules that have weakened US power and damaged the prospects for its workers. And for those followers, it seems that the actions so far are simply overturning decades of rot and failure. But even if that were correct, it would seem to me that the means by which government leaders act is important, especially for the leader of the most important, of the most powerful state in the world. Actions or threats that call into question the US government's willingness to abide by agreed rules, or that effectively say that the result alone is what counts, create huge risks. If the US abandons international legality, other states are encouraged to do the same. Instead of building shared institutions to address the many common issues that we have, like terrorism, refugee flows, environmental degradations, the approach is beggar thy neighbor, build up your military, and ensure you can win any dispute through the application of economic or maybe even military force. Everyone is exposed. The threat is constant. So what makes Trump's actions so dangerous is that the challenge to international law goes hand in hand, and we've already heard about this, with an assault on the domestic rule of law. How can we expect an administration to take international law seriously when they are dismissive of domestic law and domestic institutions? And worse, all around the world, authoritarian regimes are questioning and even dismantling the rule of law. The Philippines, Hungary, Poland, Russia, and so on, Turkey. So laws obviously limit our actions and limit state action, yes, but they protect us. And the key thing for us to understand, I think, all of us in the room and people generally, is that the rule of law is not self-perpetuating. It has to be defended by lawyers and by all citizens who may need its shelter. Nobody can afford to stand by, and we each have to think about what we can do to defend what we have taken for granted for as long as I can remember, for sure. And to end on a more positive note, it is heartening to me, as Dean Yakoguchi also said in his opening remarks, that that is happening, but we're only at the beginning, I fear. Thank you.
I have a small PowerPoint that I'm going to share with you, so Bobby's going to set it up. But before I start, I thought I would share a small story with you that will set the tone for what I want to share. I was in Boston on Friday meeting with some colleagues at Harvard, and one of them had flown in from Italy. He's a French professor named Olivier Roy, who was speaking, made a funny story. He said about 4 or 5 months ago when he'd speak to Americans, they were lecturing him how France really ought to do more to combat populism, as Marine Le Pen is seeking and gaining ground in the polls. This time when he was there last week, he was astounded by how utterly depressed, how sad they were, but how completely incapable they were, his colleagues at Harvard, of thinking politically. And I was struck by that as I was thinking about what am I going to say today, because certainly the emotions are high, but the one thing that we have as an advantage in Canada is being on the periphery gives us an opportunity to reflect. And so and it's in that spirit I want to offer a few reflections. Professor Schneiderman suggested that we think hard about facial neutrality, that the rules that we might be seeing may not single out Muslims, may not single out any particular community, but in the context of this ban that's called the Muslim ban, it's fascinating to see how it operates and how the language around it seems to be shifting into a binary. Is it a Muslim ban or is it a national security measure? The binary itself is what I want to critique. And it's a binary that I think rests on the idea that discrimination must be express or intentional. And I want to challenge that by thinking about the ways facial neutrality plays into systemic ideas of discrimination. Michelle Alexander, in her New Jim Crow, writes quite passionately about how at the end of Jim Crow, there was a greater effort to create a system of equality that ultimately got overtaken to perpetuate systemic disenfranchisement of African Americans by law that was facially neutral, passed by parties on both sides of the aisle. And it's an incredible indictment of law that and drafters of law, and in many ways offers the cover by which today's bigots and racists in the United States have claimed success. So it's in the context of that kind of conversation that when we talk about the ire and angst and frustration around a religiously directed ban, or at least what looks like a religiously directed ban, we're immediately asked to reflect on religious freedom and its centrality in our legal system. And yet, any of you who've taken constitutional law know that it's hardly free, it's hardly absolute. And Winifred Sullivan, in a phenomenal book, writes that, in fact, religious freedom is utterly impossible. We're always and at all times confronted with the regulatory power of the state. And it's in that context I want to suggest that in the current challenge over how does one describe this executive order, is it a Muslim ban? Is it a national security measure? Yes, it has a history in a visa waiver program. Yes, the specific countries identified have a longer history in terms of limited of specific exceptions to the visa waiver program under the Obama administration. Yes, the states identified have capacity issues. And yes, the countries identified are all Muslim majority. And I want to suggest that the tendency to reduce the conversation into a binary misses a larger problem, a larger heuristic that I think we can explore to our betterment. And that is in thinking about the state and the Islamic as variables, as themselves heuristics, not so much objects of analysis that we can take for granted as a given, but themselves as evolving, as reflecting upon each other in what they are. As Muslim states invoke Islam or Islamic law to justify the legitimacy of the political regime, so too do we see national security measures invoking the Islamic to justify the heavy-handed military intervention that we've been seeing around the world. And so to what extent might we trace this dynamic between, if not the post-Westphalian state, certainly the idea of Western-style governance or the Western tradition of governance, and to what extent does it allow us to see in lawyerly fashion something that Sam Huntington's Clash of Civilizations thesis covers over all too easily with neat political sloganeering. And so, being the good medievalist that I am, I thought, let's go back to 1095, Pope Urban II in his speech at the Council of Clermont in 1095. Now, there's various versions of this particular speech. I'm relying on Baldric of Dole's account of it. And what's fascinating about this passage is how prior to this particular passage where he's talking about the occupation of Jerusalem by Turks and Muslims, the heathens or barbarous nations he calls them, he actually spends most of this speech indicting what we would call Europeans, people in the western part of Europe, for their factionalism, for their infighting, and suggesting that as knights, as members of a European elite, they ought to be better. There's a sense in which he's trying to construct a sense of Europe and Europe's virtue by reference to an Islamic other. And so, as he talks about of Jerusalem, he says, we are exceedingly afraid and ashamed to speak of it. Why? Because we haven't fulfilled our responsibility. The very city in which, as you all know, Christ himself suffered for us, because our sins demanded it, has been reduced to the pollution of paganism, so the casting of the Islamic as both pollution and pagan. And they say it to our disgrace, withdrawn from the service of God. And so outside this sort of the sacred service. He goes on and talks about, but why do we pass over the temple of Solomon, nay, of the Lord, in which the barbarous nations place their idols contrary to law, human and divine? So Muslims in their occupation of the region are not only uncivilized, barbarous, as we know, very key piece of legislation from a couple years ago, the zero tolerance for barbaric cultural practices has a long history. And here we see it located in the designation of Muslims in Jerusalem, not only as barbaric and uncivilized, but as without law, as a people of no law. And so in the absence of law, what is there? And this is an interesting point for us, is that if there's no law, if Islam is contrary to law, how does one bring law? In fact, one has to recognize that the very conception of the Islamic as a notion of law has its own history, not only from the medieval historical period, but we also see it in social science theory, but also in legal practice. So here's Max Weber in Economy and Society writing about charisma, and specifically charismatic adjudication being prophetic revelation, the oracle or the Solomonic award of a charismatic sage, an award based on concrete and individual considerations which yet demand absolute validity. This is the realm proper of Qadi justice in the proverbial, not the historical sense. Qadi justice is a reference to the Islamic judge, the Muslim judge who adjudicates disputes, the term given to the figure from the 9th to 14th century, but taking shape in the 10th century as a specific office in Islamic legal history. And here, he's, in all fairness to Weber, using it more as a proxy for something else. He recognizes that historically, this is not how Qadis actually operated, but for the reception of the Weber framework, we see Justice Frankfurter in the U.S. Supreme Court invoking the notion of the Qadi as completely opposite and contrary to the very notion of what law and a court of review ought to do. This is a court of review, he writes, not a tribunal unbounded by rules. We do not sit like a Qadi under a tree dispensing justice according to considerations of individual expediency. So between the Pope and now Frankfurter, we have a conception of the Islamic as non-law, as expedient, and then we have in 2010, a representation of the Islamic as absolutely contrary to American policy. The Center for Security Policy put out a report in 2010 and in which it cast Sharia as a fundamental threat to national security in a context where it's unclear to find and identify America's enemies, both abroad and at home. How might we do so? Well, let's see who practices Sharia. Sharia is the crucial fault line, they write, of Islam's internecine struggle. 7th century impulses enshrined in Sharia have reemerged as the most critical existential threat to constitutional governance and the freedom-loving, reason-driven principles that undergird Western civilization. Just as a side note, the Center for Security Policy that sponsored the report was led by Frank Gaffney. Frank Gaffney was noted as a member of Trump's transition team on national security and has become part of a normalized conversation around what the Islamic is, despite the Southern Poverty Law Center identifying him as a purveyor of hate. And lastly, we have this way of which the Islamic and the state commingle. If the Islamic is barbaric, if the Islamic is non-law, if the Islamic is unreason, the Islamic is what fills the gap when the state is absent. So Secretary of Defense James Mattis, prior to his appointment as Secretary of Defense, speaking at the Heritage Foundation in December 22nd, he juxtaposed both the nation state and political Islam together in about a 3-minute section of his speech. On the one hand, he recognizes the nation state is breaking down. Where the nation state breaks down, think Somalia, think Sudan, think Syria and Iraq. Basically, many of the countries on the list of countries banned on the executive order. In the absence of effective state management and control, what do we have? We have armed bands. We have Al-Qaeda, we have Hezbollah. And so what do they represent? They represent political Islam, not as a specific religion, not as a specific tradition, but as an ideology in contravention to all that is as American. And he says, how are we going to have this conversation? We have to ask the question. We have to ask the question if it's in the best interest of the United States. And in doing so, perpetuates an ongoing binary, a binary that actually tracks more effectively a functional versus a failing state in which the Islamic nonetheless takes part. We can talk about why he doesn't put Saudi Arabia on the list. We could talk about why the Gulf states aren't there. Certainly some of the arguments are that, well, he does business there. However, I think that's a bit of a misdirected argument. The fact is there are more effective states in managing their populace than the others are. And so the more we think about law in the service of the state, Section 1 and the work it does to preserve the autonomy and sovereignty of the state over and against the individual, I want to suggest Islam in the context of this executive order is constructed like any other thing: race, gender, social constructs, the Islamic is constructed here or abroad in the service of a state whose policies in the context here of national security are no less constructed as well. And so as we think about what the executive order signals, as we think of our outrage, I want you to think about how the language of law is actually covering up a much more long-standing consideration of the relationship between the Islamic and the West, not so that we can perpetuate the Huntington thesis, but perhaps we can get past it. Thank you.
Hello, my name's Audrey Macklin. I'm the director of the Center for Criminology and Sociolegal Studies and a professor here at the law school. Before I start my talk, I would like to acknowledge with gratitude the extraordinary efforts of law students, some of whom are in this audience today, who spent this past Saturday conducting a research-a-thon to gather jurisprudence and data and evidence that might be relevant to challenging Canada's continued enforcement of the Safe Third Country Agreement, as well as other related issues. I'd also like to thank colleagues who signed on to a letter containing more than 240 names of law professors around the country calling on the Canadian government to suspend the Safe Third Country Agreement and to facilitate more refugee resettlement. And finally, if that poster was back up, I would tell you about a meeting that will take place here on Friday, February 10th, which is a town hall meant to be university-wide to discuss what the university as an institution and as a community might do to enhance the efforts that are already ongoing to respond to the impact of the Trump ban. Now, for the remainder of my time, what I'd like to do is talk about the domestic face of the Trump ban and perhaps what it can tell us about borders and human rights at this moment. So let me start from a presumption of agreement, which may not be shared by everybody, but I'm just going to put it out there, that banning non-citizens from entry on account of their national origin or religion as such violates international human rights instruments to which the United States is a party, as well as Canada. That would be the International Covenant on Civil and Political Rights. And aspects of the ban may also violate the Refugee Convention. It's not as clear how the Refugee Convention is implicated explicitly in the ban, because the ban, to the extent that it talks about refugees, is referring to resettled refugees and not to those who arrive as asylum seekers. That's not the full story. There's much more to be said about it, and I'd be happy to answer questions about it. In reference to the U.S. Constitution, David has, of course, done a wonderful presentation about that. I would only add that there is a doctrine in United States constitutional law known as the plenary power doctrine, which operates to grant the executive even greater discretion in the enforcement of immigration law, to insulate from constitutional scrutiny at all legislation and executive actions taken toward non-citizens. And I won't pursue that here. One way of thinking about the Trump ban is as a spectacular enactment of a kind of cliche about what sovereignty is and how it and what it means. And that is this, that borders are fixed and invariant. Sovereignty manifests itself in the power to police who crosses and who does not and on what terms. And what happens at or inside those borders is no one else's business. Now, the Trump ban seems to display that for us in a certain kind of aggressive way. But paradoxically, I think it also exposes the kind of pathology and distortions that this characterization of borders and sovereignties carries with it. And what I'd like to do is illustrate that by reference to the spillover effect in Canada. So one idea about borders and sovereignties that, as I said, borders are fixed and invariant. But in fact, of all the things that move around, borders move around. Not just people across borders, but borders themselves are mobile. And one of the places where the US border is happening is here. It's here, it's happening at Pearson Airport, it's happening at the Vancouver Airport, Ottawa, Montreal, everywhere else in Canada. that operates a pre-clearance program, where you get to cross through the Customs and Border Protection agents while you are in Canada en route to the United States. You are pre-cleared so that when you arrive in the United States, you don't have to do that again. But what that means is that the US border is being enforced on Canadian territory. This is, of course, convenient for lots of people, and so we haven't particularly troubled ourselves about it. But I looked up the Pre-Clearance Act, which is the statute governing this arrangement. And it's surprisingly thin, but one of the provisions, Section 4, says, maybe Section 6, whatever, says that the conduct of pre-clearance officers must be consistent with the Canadian Charter of Rights and Freedoms, the Bill of Rights, and the Canadian Human Rights Act. Now again, perhaps there's disagreement and one would have to spell it out in greater detail, but I'm willing to tell you, dollars to donuts, that this ban would violate the Charter and the Canadian Human Rights Act and probably the Bill of Rights as well. So the question then here is, a law of the United States that violates Canadian constitutional law is being enforced on Canadian territory. Now, what does that tell us about sovereignty and borders? Okay. The question of what to do about that is an interesting one. Presumably, it could be challenged in law. Where does one go from there? Well, at best, one could make an argument that the Pre-Clearance Act shouldn't be applied on Canadian territory. But if we are concerned about Canadian involvement, if you will, complicity in the enforcement of the ban, then it's worth thinking about how the pre-clearance zones operate. Okay? Some of you, I, carry a Nexus Pass. You may know about these trusted traveler programs that give us privileged access to crossing the US border. Now, we're all used to kind of hierarchies of foreigners. That's how immigration systems work. So we just become a little rung higher in the hierarchy of foreigners entering the United States. You may have heard that these Nexus Passes have now been revoked for those who hold them who are citizens of the 7 banned countries. That is typically permanent residents of Canada. But here's the deal about Nexus Passes. They don't also give you privileged access to the United States as a foreigner. For reasons that are still a bit unclear to me, they also give you privileged access to Canada. When you come back to Canada, you get to the head of the line. You have privileged access in a variety of ways to and within Canada because you're the holder of a Nexus Pass. To the extent that these passes are now being dealt out and revoked according to the application of law that we might view as discriminatory and contrary to the Charter, the Bill of Rights, the Canadian Human Rights, again, it raises the question of whose law is being applied here by Canadians to Canadians on Canadian territory. Another feature that we think of borders, what happens at borders, or is invariant, borders content is in some sense fixed. And furthermore, what goes on inside a border doesn't trouble us. So let me speak here then of the Safe Third Country Agreement. The Safe Third Country Agreement was signed between Canada and the United States in 2004. And it provides that as between the two countries, if an asylum seeker arrives in one, he or she must make a refugee claim there and cannot proceed to the second country. You have to make your refugee claim in the first country of arrival, as between Canada and the United States. Now, there are various exceptions to this in areas where it doesn't apply. Again, I'd be happy to explain in greater detail what those are. But just take as given that that's how it works. So what it does is a border that used to be one that could be crossed by an asylum seeker. I'm standing on the US side of the border and I say, I'd like to make a refugee claim in Canada. That border was once porous. Now it is not. It is more of a wall. You get rebounded back to the United States. You must make your refugee claim there. It operates, of course, reciprocally. But the truth is that the flow northward has always been far greater than the flow southward. And the existence of this agreement is entirely attributable to Canadian interests in reducing the flow of asylum seekers entering Canada. Now, the predicate of the US-Canada Safe Third Country Agreement, incorporated into the title, is that they're both safe. That is to say, they are countries that are each safe places for people who meet the definition of a refugee to make their refugee claim. Okay? If one or the other of the countries is not safe, then you have undermined the normative justification for this agreement. Because if one country isn't safe, then there's something problematic and possibly unlawful about the other country denying entry and rebounding a person to that country that is unsafe, where they may not get a fair chance at obtaining refugee protection, and worse yet, may get refouled, which is to say returned to the country where they have a well-founded fear of persecution. So although the executive order does not actually explicitly talk about asylum seekers, there are a variety of scenarios and anecdotal reports about how, in fact, it is being applied in a way that has the effect of obstructing access by asylum seekers in the United States to refugee protection. This then puts into question whether the United States is a safe country, which further forces attention to Canada's conduct in continuing to enforce this agreement. Canada has been called upon, and among other things, the letter that 240 professors signed, to suspend that agreement, but has thus far refused to do so. So on the last point with respect to refugee resettlement, here is an issue where legal obligations, in fact, are not applicable to Canada, and Canada is not in breach of any particular legal obligation. Rather, there is a call out for Canada and other countries that engage in refugee resettlement to come to the aid of those who have been, apparently I have to stop talking now. And it won't stop. That's it, I'm done. Okay, I'm done. So the call on Canada and other states to resettle some of those refugees who are destined for the United States, been given visas by the United States, and haven't been entitled to enter. And that is not so much in the realm of law as it is in cooperation. Now, Lisa's going to talk about the impact on privacy, about some of the actions at the border, at the US border, going on with respect to the seizure of cell phones, requirements of data sharing, and so on. And I'll leave it to Lisa to do that. So maybe I'll just say this. There's a whole other, I guess I'm joining with other people in saying, you know, after 9/11, I kind of became this born-again believer in the rule of law. And then I kind of lapsed back into a bit more of a critical perspective. I'm back on side again. Okay. And there's lots more to be said from, if I will put it this way, an administrative law perspective about very significant rule of law concerns around the implementation of this ban. Thank you.
Thank you. I'm Lisa Austin, and I'm a professor here. One of my research areas is privacy, and I wanted to focus my remarks on some of what Trump is doing in relation to privacy, particularly privacy of what we call non-US persons, so non-US citizens, non-US permanent residents. But to start, I've been thinking a lot about a talk I attended right when the Snowden revelations started breaking a number of years ago. And I was listening to a former NSA analyst and one of the original whistleblowers in the NSA, William Binney, speak here in Canada. And his position, which seemed so extreme to me at the time, was part of the problem with the sort of surveillance apparatus that the Snowden revelations kind of brought to light, and which he had seen when he was an analyst in the NSA. He was there as they were building it, so to speak. Was that he said, you know, we are this close in the United States to creating what is, you know, turnkey totalitarianism. And at the time I thought, wow, that's a really extreme view. But, you know, I have to say in recent weeks, thinking about this in relation to what we've heard about in terms of the assault on the rule of law, the strong anti-Muslim, anti-immigrant sentiments of the people in the Trump administration, it gives one pause. And I think to add to that, I would say that Trump has surrounded himself with people who are firmly in favor of expanding the U.S. surveillance state. So I'll just give you a quick quote from Mike Pompeo, who's the new CIA director. Last January already, he put an op-ed in the Wall Street Journal where he said, "What's needed is a fundamental upgrade to America's surveillance capabilities. Congress should pass a law re-establishing collection of all metadata and combining it with publicly available financial and lifestyle information into a comprehensive searchable database. Legal and bureaucratic impediments to surveillance," that would be the rule of law, "should be removed. That includes Presidential Policy Directive 28, which bestows privacy rights on foreigners and imposes burdensome requirements to justify data collection." So this is very much, I would say, there are similar sentiments in public statements you could find with Jeff Sessions, Trump's nominee for the Attorney General, Michael Flynn, Trump's national security advisor. So we can add to assault on the rule of law, anti-Muslim, anti-immigrant sentiment, expansion of the surveillance state. And I think that there's a couple sort of recent developments that show that this is exactly what is going to happen, and that if you put the expansion of the surveillance state along together with anti-Muslim, anti-immigrant sentiment, you're going to get an assault on privacy rights of non-U.S. persons. So American law makes many, many distinctions between U.S. persons, so U.S. citizens and permanent residents, and non-U.S. persons, that would be us. And so on January 25th, the executive order that Trump set out has a section that got a little bit of press attention, but not a lot. It's the Enhancing Public Safety in the Interior of the United States executive order. And Section 14 of that said that all federal agencies shall exclude non-U.S. persons from Privacy Act protection in the United States. So what does that mean? First of all, I mean, the Privacy Act in the United States doesn't apply to non-U.S. persons in the first place, so the statute just doesn't apply. But as a matter of policy, it actually, those protections had been extended to non-U.S. persons because very many federal agencies have what are called mixed databases. So, the Department of Homeland Security, for example, would have databases that would have a mixture of personal information on U.S. persons and non-U.S. persons. And in those mixed databases, for years, they've had policies in place that say we're going to treat them all as if they're U.S. persons. So as a matter of practical policy implementation, we had those protections, with the exception of you couldn't go to court if you had a kind of complaint about it. But other than that, we had those protections. That's what's being rolled back. And so what does that mean? What do Privacy Act protections include? Well, a couple of things that are important. One is you can, ask an agency to get access to the data they have on you. So you just want to know, what data do you have about me? You can correct for inaccuracies. So you can correct the record. Those are important rights. But also, there's a lot of protections around the further dissemination of the information. So the agency might have collected the information for one purpose. There are all sorts of protections for when they can actually then use it for other purposes. So a lot of sort of strict protections that around the dissemination of that information, the further dissemination of it. So basically, this opens up information sharing and reduces transparency with respect to information practices for non-U.S. persons. Okay. Now, the context of that executive order was the interior enforcement of immigration laws. They're basically trying to make it easier to remove what they call removable aliens. But it has this wider impact because it applies to all of the federal agencies now, and that sort of protection by policy doesn't apply anymore. The media coverage of this was mostly focused on Europe because the United States and the EU just finalized a new, what they call the Privacy Shield, which is this kind of legal mechanism that allows data to be shared between the US and the EU, so that an EU company, for example, could use US-based cloud computing or something of that sort and not run afoul of what are stricter data protection laws in Europe. So Europe has stricter privacy protection than the United States as a general matter. Okay, so they created this new Privacy Shield arrangement, and all sorts of concerns were that this removal of Privacy Act protection was going to call that into question. I tend to agree with the folks who say that although there's other problems with the Privacy Shield, that's not the problem. And the reason is that actually, in terms of implementing this shield, which again is about Europe and the United States, not about us, the US passed legislation that's not affected by this new executive order called the Judicial Redress Act. And what it does is it gives Privacy Act remedies to citizens of designated countries. And one of the last things that Obama, the administration did was designate a whole bunch of European countries. Okay, Canada is not designated. big miss on the part of the Canadian government. Now that we're going to have Sessions as the Attorney General, I don't know that we'll get on that list. So I think Europe's okay, but Canada's not. That we don't have the Privacy Act protections anymore that we used to have as a matter of policy. And it's not clear how to enforce that. Canada has something called the Beyond the Border Action Plan. The whole point of that was to facilitate greater and greater information sharing as between the Canadian and US authorities in order to secure our large shared border. There is a statement of privacy principles, a joint statement of privacy principles that go along with that action plan. Those principles do not have a status of law. Again, a big miss on the Canadians' part there. And the general statement of principles for the Beyond the Border Action Plan says, we value and respect our separate constitutional and legal frameworks that protect privacy, civil liberties, and human rights, and provide the appropriate recourse and redress. We recognize the sovereign right of each country to act independently in its own interest and in accordance with its laws. That's not going to help us either. I mean, it's just a statement of principle. But there's this idea there that they had that was a real misfire of, well, as long as, Canadians are protected by Canadian laws in Canada, and Americans are protected by American laws in the United States, we're all good to go. But when information is crossing borders, we have to think about the protection of the information when it's crossed that border, and if we're being protected as non-US persons and not being protected, that's actually a huge problem. So that does affect us quite seriously, I would say, and now Europe has better protection than we do, and we're the ones who share the border. So that's a problem. The second thing I wanted to talk about, which did get a little bit more press coverage, was around searches at the border, particularly searches of people's cell phones and social media accounts and contacts on their cell phones. So there's been a number of media reports. Some of them started when Canadians were trying to cross the border to take part in the Women's March in Washington and were sent back. There were reports that some of the people who were stopped were having their cell phones searched, including their social media accounts. The suspicion being that they were looking for evidence that they were going to go and take part in the march, and that might have been one of the reasons they were turned back. It's hard to know for sure. There have been media reports that persons detained in the U.S. airports as part of the Muslim ban have had their cell phones searched, and including their social media accounts and, again, their contacts as part of that. CNN reported also that actually the Trump administration was thinking that they should just make this a general requirement of all foreign visitors, that their phones can just get searched and their social media accounts. As it turns out, the current position of American law, and I would say the same thing for Canadian, is that the view is at the border you have a lower expectation of privacy and they can do these searches. And it's just that we haven't seen so many of them. They can search your laptop as well. Civil liberties groups on both sides of the border would like to challenge these practices, saying that the laws that authorize this are the same laws basically that say, you can search someone's suitcase. A suitcase is different from a cell phone, and maybe we need to rethink this in the current age. So that's certainly something that's happening, and we're on notice that it's going to happen more in all sorts of different contexts. I think, though, that we should actually be challenging the searches of cell phones at the border, and this includes also they're forcing people to hand over their passcodes. So if you think you're going to secure your phone just by securing it that way, think again. But there was this great article in Forbes recently, and I tend to agree with it, especially when what they're looking for increasingly is they want to know your social contacts, right? And they want your social media accounts too. That whether it's your phone is kind of immaterial. What the phone is doing is it's connecting you with a lot of other information, and that other information is available in the cloud, right? And there was this great article in Forbes, I just wanted to quote from it. It said, "Most troubling, though, is that as the cloud becomes the center of our lives, the discussion of border screening will likely become less about scanning physical devices at the border and more about tying visitors to their cloud identities and screening them in secret before they ever get on the plane, using the NSA's vast planetary data vacuum, meaning this is likely the last time we will ever even have a public conversation about border screening." And I think that's also sobering as Canadians. I'll sort of end on this cheery note. Which is that we are great consumers of US-based cloud computing services, all of us. And that data is in the United States. that data is in the United States where you are a non-US person. And not only does the Privacy Act not apply, but it's also very clear that the US Constitution does not apply to you as a non-US person when you physically remain in Canada. So when you're in the United States, if you're physically there, the Fourth Amendment, which is like our Section 8, which protects you against unreasonable search and seizure, if you are physically here and your data is there, the Fourth Amendment does not apply to you at all. Nor does the Canadian Charter. Your data, you've put it in what I call a constitutional black hole. And if this is what they're trying to get access to then regulate whether or not you can enter the government in all these different ways, then I think we need to think seriously about that as well. So I'll leave you with those cheery notes.
So thank you very much to all our panelists. Microphones set up on either aisle, which I'm not using, which will mess up the web broadcast. But I would encourage you, if you have questions, to come down to the mic and ask our panelists in our remaining time. Who would like to start? No? A lot?
Hey, I'm ready to go home.
Yeah. Do you want to ask questions of one another?
Ask a question. Well, my question is very pedestrian, and it relates to my using social media, actually, but the question is not for Lisa, but it's for David. I happened to watch a little clip of a Justice Department lawyer pleading before the so-called judge in Washington State, where he made the comment about that it had to be rational and, didn't seem to pass the bar. And she basically responded back to him something to the effect, well, that's not the test we're arguing. We're arguing it has to be, quote, facially legitimate. And I sat there and I thought, is that a thing? I mean, this is a serious question. Is there such a thing in U.S. constitutional law? It would strike me as a humble international lawyer that as a lawyer you don't make an argument about it being legitimate, but about maybe facially or prima facie legal.
The Department of Justice is making extravagant claims. In this case, they're saying basically the court can't look beyond the language, right, in the executive order. This is the appeal document to the Ninth Circuit from that decision, and they make this argument. Judicial second-guessing of the president's determination that a temporary suspension of entry of certain classes of aliens was necessary at this time to protect national security. So judicial second-guessing would constitute an impermissible intrusion on the political branches, plenary, and this is what Audrey's getting at, constitutional authority over foreign affairs, national security, and immigration. Right? So they're asking for complete and utter deference. If you watch the argument, it's actually all on available on a government website. The whole argument. Noah Purcell, who is arguing for the state of Washington, says not the test, and he's right. There's lots of precedent to suggest that's not the test. That courts can examine and scrutinize to some degree. Again, it's rationality, and here, of course, the argument is there's not even a rational connection, right? I mean, you've got 7 states who haven't, evidently exported terrorism to the United States, and Saudi Arabia, of course, was the home of most of the 9/11 bombers. And then there's a more cynical argument that I buy into, that the 7 states that are included in the ban are not places that the Trump enterprise operation does business, and that the Muslim countries where Trump operates are not banned. So there are all kinds of reasons to scratch right beneath the surface, and it's interesting that every federal court that's heard the case, even in Boston, though essentially giving up on the temporary restraining order after 7 days, still initially granted those temporary restraining orders. So they were convinced that something more needed to be shown, and it wasn't shown here. So the Department of Justice has always made extravagant claims on behalf of presidential authority. I mean, that is basically has been their job for the last 25 years, which is why the position that acting Attorney General Sally Yates took was a bit of a surprise, because they always make imaginative and extravagant claims, and she refused to. Right, it's an extraordinary moment when she made that admission, but of course it took little, right, to find somebody else, and then the whole apparatus of the Department of Justice to then steam ahead. But I don't think the federal courts are going to buy that.
I had a question, if I may ask, of Audrey, because I know, Audrey, you've been, you opened with a number of things that students have been doing, and I've been getting a lot of questions about what one can do from Canada, and maybe I could put you and perhaps even Samer on the spot if I might ask him to take the mic, if that's all right, about what are the options here for people who are troubled but also feel the imperative to do something and put their legal education to work, whether they're first year or second year or third year law students or even some of our alumni who are watching.
Well, I've mentioned a couple of the initiatives. There is also a new cross-border initiative. And there's somebody named Corey Sheffman. Is he here? Nope. Okay, who has founded that. So it's actually a kind of volunteer initiative to go show up at the airport and provide free legal advice or assistance to people who are confronting pre-clearance. I think that there are, in terms of what can be done on the Canadian side, the first recourse, it seems to me, is to direct our attention to what the Canadian government can do, isn't doing, could do, and to use what political voice we have to advance better policies. It is striking to me that in response to this ban, our government sent out a tweet about how, about how great Canada is and how we don't do this sort of thing. And indeed, the New York Times just published some very flattering article about Canada, bastion of the free world. But and I have lots of good things to say about Canada's, about the response of individual Canadians to Syrian refugees and, a lot of things. But the fact remains that in response to this ban, the Canadian government has done nothing. Nothing, right? So we have in place the implementation of it on Canadian territory at pre-clearance zones. We have the continued enforcement of the Canada-US Safe Third Country Agreement. We have silence about the impact that this has on Canadians from the Canadian government. So each of those strike me as opportunities for speaking up. As lawyers and students, there's research to be done. So advocacy to be done in all sorts of fora. And I don't actually think legal advocacy is the only or even the best route. Right? I think there are lots of other ways to advocate. And litigation is but one of them. So, thanks. Samer?
Hi, I'm sorry I came in a little bit late, so I don't know if you've already answered this. But there's a question that has been bothering me for a little while, and it's a little bit technical, so I couldn't find a lot on it. I read that it is very possible and likely that there will be implications for American expats abroad, in the sense that ISIS might target them because of everything that is happening politically. Since the ban mostly applies to people who are not American citizens, so if they bring individual cases, there's a possibility that the court will apply the political question doctrine, or say that the Constitution, I guess, not the Charter, doesn't apply to them. However, is there any precedent, or would this work if the American expats abroad, once there is some kind of a risk that manifests, could they sue the American government? I would say, I don't know about the American Constitution that much, but I would assume something like Section 7 of the Charter, basically saying that there has been an increased risk to their life, liberty, security of the person, I would assume life mostly, would that be a legal avenue that some Americans could take up? Thanks.
It's hard to know precisely what the answer to that is. I'm certainly not an expert on American civil procedure, but American citizens presumably would have standing if they're injured, right, in American courts. That they could meet that standing requirement if it's particularized and concrete. And attached to or appended to the state of Washington's response to the appeal of the emergency motion that they secured, I thought was quite interesting, was an affidavit from Madeleine Albright and others, right, former Secretary of State. And they declare in paragraph 5 in their professional opinion that the order will endanger U.S. troops, intelligence sources, feed the recruitment narrative of ISIL, disrupt ongoing law enforcement efforts, have a devastating humanitarian impact, and will cause economic damage to American citizens and residents. They don't talk about life, but they do talk about property. So you could imagine that, right, this is the kind of evidence that they're proffering to the court. So it's foreseeable, right? And that's another standing requirement, kind of you can trace the injury to the conduct of the defendant, and so this kind of damage is foreseeable and redressable to some extent. Damages, right, could be owed. So I don't see why that actually couldn't move forward based on the evidence on the record, even that Washington State's putting forward. Does that help?
Sorry, I was mostly wondering as a constitutional challenge. Could they raise a constitutional challenge based on the fact that the executive order increases the risk to their lives?
That raises, again, questions of standing that they might have, but all the problems that I was mentioning, which I was rather equivocal about the success of Washington and others and individuals in reversing the executive order. I don't think courts are particularly reliable allies in these kinds of circumstances. Judges generally will defer in these kinds of matters. These are determinations best made by the other branches. It's a separation of powers argument. As I said, Trump is weakening that argument by his behavior, but in terms of succeeding in a constitutional challenge, I was just making a standing argument, which is the first hurdle in any of these kinds of constitutional claims.
Hi, I just wanted to go back to what you were saying just before this question, Professor Macklin. I'm, with you. I hope that the Canadian government does take a stand, or and suspend the Safe Third Country agreement. But on the other hand, it seems like Trudeau has to play some sort of long game and not, taking off the very sensitive leader south of the border. So I'm wondering how you see it playing out following the message that was sent by students all across Canada and other lawyers and advocates. What do you think it's likely that the Canadian government will suspend our part of the agreement?
If I were laying odds, I would not bet on Canada suspending the agreement. Let me elaborate, though, on a couple of other options, or at least one other option. Article 6 of the Safe Third Country Agreement also permits the minister to, through his discretion, create exemptions to the application of the Safe Third Country Agreement on a public policy basis and on an individual basis. So that would be, in some sense, a less threatening, a less dramatic way of proceeding. So that with appropriately framed guidelines, or ministerial instructions, the minister could just decline to enforce it in individual cases. That could be temporarily limited. We're not going to enforce it for the next 6 months, or we're not going to enforce it to refugee claimants from the listed countries. I want to inject a cautionary note about the way in which this executive order operates, because it would be a mistake to understand its effect as limited to whatever the text says. First, because the text is incoherent and vague and confusing. Secondly, precisely for those reasons, a zone of extraordinary discretion opens up for those on the ground who are applying, implementing, and enforcing it. There is confusion, havoc, chaos. The difficulty is that it's not just people from those 7 countries who are likely to be affected, because border officials are applying and implementing it in a kind of arbitrary way. And people are legitimately afraid to come forward and pursue asylum claims, even if in law they should be able to do so, right? So, and those will be people from all over. People are just scared for, very, very good reason. So that points to a limitation of something like litigation as a solution, because litigation has a really hard time dealing with the pernicious effects, not of the text of a law being applied, but the zone of arbitrary discretion that it creates, where these outcomes are anecdotal, impressionistic, occasional, unpredictable, and so on. So that's, I think, one kind of response to this. I don't think it's, there's litigation that's begun to challenge it, and who knows where that will go. It's possible that if litigation to suspend the agreement has legs, that might provide an incentive for the government to exercise a little more, to use the discretion it has and adopt this softer route, if you will.
Could I add something to the question about what Canadians can do, what we in Canada can do? What we really need to do is vocally condemn racism, nativism in all its manifestations, because we're not immune to this, right? We've sort of been silent about the presence of this kind of discourse in Canada. I need not mention the killing at the mosque in Quebec City. But our political leadership, right, has, Anver mentioned, Barbaric Cultural Practices Act. The Progressive Conservative Party ran part of its last election campaign premised upon condemning Muslims, right? I mean, that's what it was in part about. Kelly Leach is running her leadership campaign for the Progressive Conservative Party on a similar kind of basis. And the Parti Québécois Charter of Human Values, again, was premised on isolating, separating out, and condemning Muslims. And it so happened that Jews also got caught, so they kind of had to admit that, acknowledge that, and allowed Jews to wear earrings with the Star of David on them. So we should, and that didn't work out so well for the Parti Québécois. It could have, right? The strategy was to use that kind of division to secure electoral success. So I think we have to be vocal and vigilant. And that's one thing we can do, I think, all of us here in the room.